My lord, my ladies, I was going to, on the point of novation and clause 16. My lord, just to recap by summary, as far as Astra UK is concerned, we are looking at a novation problem, not some bipart arrangement, not some estoppel, straightforward novation, but I have estoppel in this. As far as Astra LLP is concerned, I say I've got a novation, or at the very least, a novation by estoppel. That's the context against which to judge the no variation clause and the authorities. Now, the relevant authority is ROC, which is at page 437. Page 437 is the first page I want to go to. I think it begins slightly earlier. 431. Now, this was a case concerning a license agreement which contained no oral modification clause. And you can see that clause at page 437. Judgment of law assumption. Paragraph 2, MWB Business Exchange Centres operates services office in central London. They enter into a contractual licence. Clause 7.6 of the agreement provided. This licence sets out all the terms as agreed between MWB and licensee. No other representations or terms shall apply or form part of this licence. All variations to this licence must be agreed, set out in writing, and signed on behalf of both parties before they take effect. So there it is, it's a no variation clause as well as effectively a no representations clause. Relevant part of the judgment is at paragraph 15, at page 442. And perhaps I can just ask you, my lord, my ladies, just to read 15 and 16 to yourselves, and then I'll just make a comment on them. Yes. 2 points. First, this is talking about, quote, variations. You get that from the third and fourth line of paragraph 15, and the last 4 lines, I think, of paragraph 16 of page 442. Variation. That's what we're talking about. They're not talking about novations. And for the reasons I've already explained in my submission, a novation is quite different from variation. A novation proceeds on the premise that the old contract with the no variation clause has gone, and a new contract with different parties has come into existence. That, in my submission, is that. There is a difference, a fundamental difference, between the two concepts. And if my lord, my ladies, a party wants to exclude even that, in my submission, they would have to put that in expressly, and they could do. And it would be a very surprising way of going about things to say, oh no, there can't even be novations involving new parties who aren't bound by the old contract. That would be an astonishing thing. If you want to put that in, well, you put it in. But on the face of it, it's a very strong thing to say that a party who's not a party to the contract is bound by a clause in an old contract. Doesn't make any sense, unless conceivably you stick something in the existing contract which somehow precludes even the new party to the new contract relying upon the new contract. But that, I submit, is conceptually very difficult even if one could do it. But anyway, you're going to have to do it clearly, and it's not done at all. And there's nothing in this judgment here which suggests that what their lordships are talking about extends beyond variations, properly so called. And that's what this case was about. The second point is what you get at page 442, starting with the reference to the Vienna Convention in paragraph 16 about estoppels. Now, what Lord Sumption says here is, well, this is not the place to debate that issue, but you're going to need more than just the sort of some rather vague allegation that assurances were given. You're going to need to establish an estoppel to get any such argument off the ground. Well, here I say we have established an estoppel in both cases. That is, both in the case of Astra LLP Novation and in the case of the Novation on to Astra UK. And in particular, you'll note at the top of 443, there would have to be, at the very least, some words or conduct unequivocally representing that the variation was valid, notwithstanding its informality, and two, something more would be required for this purpose than the mere informal promise itself. Well, we've got that here in my submission. The parties, there's a clear representation here that the variation, or sorry, the novation was valid, and indeed the parties acted on that basis. And it would be quite, in my submission, quite unconscionable, the parties having acted on the basis that they did, for Astra UK now to turn round and say, oh, there's that no variation clause. And quite unreal, I might add as well. So that's my submission. First of all, it doesn't apply at all, because it's talking about variation. Secondly, even if contrary to my submission, it does apply, it certainly doesn't apply in where you've got, as here, a clear estoppel. I should just say, on the point about Astra UK and estoppel, which Lady Justice Whipple asked me about before lunch, it's not pleaded in relation to Astra UK in the particulars of claim, but it does come up in the reply. And one has to start with the defence at page 424 of the second core bundle. Paragraph 178. This is where the defence is dealing with the onward novation, or the alleged onward novation to Astra UK.
Right, we were showing this yesterday.
Yes, 178, but I want to show you a particular part of 178. It's a bit in the verb, Astra UK hasn't sent the claimant invoice and so forth. But then it goes on to say, paragraphs 140 to 169 above are repeated. You might think, what's all that about? Well, what it's about, if you go back to 140, this is the part of the pleading which deals with the novation to Astra LLP. So what they're doing is they're incorporating into their defence in relation to Astra UK what they've said in relation to Astra LLP. That's the purpose of it. And amongst the things they incorporate is paragraph 167.4. Yeah, I should have given you the page number. It's at page 422, I think.
164, did you say?
Well, it's 167.
Sorry.
Subparagraph 4 at 422. Four, it is denied that the operative contract was ever novated to LLP, further and in any event. First, the point is taken on clause 16, and that is provided that no variation of the agreement will be effective unless signed and so forth. The novation of operative to LLP would have required an amendment. So forth. Then they go on to talk about clause 17. So that's what they're saying in relation to Astra UK, to which we reply, if one goes now to the supplementary bundle, page 46, page 46, paragraph 139A. In answer to the repetition of paragraphs 149, 140 to 169 in paragraph 178 of the amended defence, that's what I showed you, the claimant repeats mutatis mutandis 118 to 136 above, which answer those parts of the defence. So you then go and see what we've incorporated by reference in answer. I'm sorry, it's all referential, this.
Yes, yes. I feel we're going deeper and deeper into the rabbit hole. Yes.
But you're just about to come out of it. But I know, my lord, it is, but a pleading's point being taken against me, and I'm entitled to say, no, it's there.
Of course.
It's there.
So where are we going now? What page?
Well, you're now going to paragraph 125. Well, it's not the...
Of this document?
Of this same document.
125.
Paragraph 125 is what we say in relation to clause 16 in relation to Astra. And in particular, you'll see what we say in relation to the, on the novation to Astra LLP at 1251. So we're incorporating this by reference in relation to Astra UK.
So this is more of the same as the judge described it.
Exactly. And then page 45, we again repeat the point. And this is basically, we've said in relation to 2B, there's an estoppel if you're relying on the no variation clause, and we're saying in relation to Crown at 136, there's an estoppel on the no variation clause, and we're incorporating all this mutatis mutandis in relation to Astra UK. So the only point I'm on is the pure pleading point. And I say the pleading's there. We pleaded the estoppel in relation to Astra UK. It was perfectly open to the judge, therefore, to find as he did. Now, I should say that initially, when we got the draft judgment, I had overlooked that we'd made this pleading, and I wrote to the judge and said, part of our comments, I'm not sure about your finding in relation to Astra UK, there being an estoppel. You might like to think about it. We say it doesn't matter, you're entitled to find as you did. He made no alteration to the judgment. There was no comment from the defendant on that point. It was us who pointed it out. In the event the point stayed in the judgment, I then realised my mistake in drafting the skeleton. In fact, before we drafted the skeleton, I think it was one of the earlier skeletons on this appeal. That's how this point has come about. But I submit it doesn't really matter how it came about. The point was pleaded. That's it. My lord, my ladies, the next point is clause 17. I should just take you to that. This is the no assignment clause.
Well, it's broader, isn't it?
Sorry?
It is broader than assignment.
Yes. Forgive me. I'm just digging it up.
Page 358.
Well, my lady, in my submission, the parties can waive that. That's something which either party can waive.
Right. So that's your case. That was waived.
Yes. Either party can waive that. In other words, if both parties consent, I mean, what this is saying is you cannot unilaterally do this. But if what happens is you do it, then I say that's fine, and we all carry on that basis, then this clause doesn't stop that. And anyway, the estoppels are a complete answer to it. And this, but basically what would happen here, what this means is, strictly speaking, let's say on the assignment, on the novation from LLP to UK, it might be said, well, there was a transfer of rights without our consent, prior written consent. We could have complained about that. We could have said, oi, look at clause 17. But we didn't. We waived our right. But this is not saying that if this happens, then the transfers have no effect. It's just saying you're not allowed to do it. But if A does it and B says that's fine, and both parties, I emphasise this, both parties then act on that, and an estoppel arises, then the party whose consent was required is plainly entitled to rely upon the novation. My lady, I also add this. This doesn't apply to novations anyway. if the old contract's gone and a new contract is sprung up, and so you get the odd.
I mean, it does say deal in any manner with rights and obligations, and a novation involves those obligations disappearing as far as
Yes, I suppose that's right. Yes, but is that dealing with? In my submission, not necessarily. If if the parties agree to terminate, I mean, the effect of this clause, if your ladyship's right, would be that parties, if they wanted to terminate early, would need to do so in writing. In my submission, that's not what it's saying. But in any event, my lady, you have my basic point. This doesn't stop. This is a prohibition. It's not saying if this happens, that there is invalidity if the other party accepts what has been done. But if the point had been the other way round, let's say, supposing what had happened is it was us who had transferred our rights, must have transferred their rights to another introducer, then I can see that Octave would have been able to say, hey, that assignment of your rights, transfer of your rights, has been done without our prior written consent. We don't consent, and we're now going to object to this being a valid, it's not a valid assignment, it's not a valid transfer. But that's the other way around. But if, so to speak, the victim, if the person whose consent was required is prepared to give it, I submit it can't possibly stop that. And that would be a very odd argument. That's what it comes down to. And also I have my statement. But my lady, you have the points. I'm not sure how much of a point this really formed in front of Mr Justice Freedman, but there it is. It's a point of law, and I accept it has to be done. This is my final point I want to make on novation. My learned friend made a lot about the distinction and the judge's failure, he said, to draw a distinction between, quote, the investment manager and, quote, the manager, Octave Limited and Octave LLP under the agreement. I say that's not a fair criticism. In a sense, I'm just going to repeat the points, but in this context I've already made. The judge does deal with the Octave Limited and Octave LLP position. He accepts that they agreed with Mr III that they would drop out. He makes that finding in relation to both of them. Further, the judge, having accepted that that was the agreement made by both Octave companies, was entitled thereafter to say that there was no reason why Astra LLP could not take on the responsibilities and rights of both. There was nothing to stop that happening. And further, the point I made at the beginning, there's not a shred of evidence that Astra Capital in any way became involved in the proceedings after the transfer over to Astra LLP. A fortiori to UK, it looks as if it was never even intended to have anything to do with the UK, because everything was going over to UK. And there's no reference to Astra Capital at all in the 20th of April email. As far as I now move to construction, I don't know if we have got various copies available. We have got copies available of the Network Rail case, which
I'm not sure we need copies. I just wanted to point out that that's a drawing together, of the principles that the judge goes through in some detail.
She does. Well, in my submission, broadly, it does help our position, but I can deal with it anyway without necessarily taking it to the case.
Well, if
we've got copies.
Yes, well, since somebody's gone to the trouble, let's have them. Thank you very much.
Thank you, Tom.
All right, so when you're now talking about grounds 2 and 3 compendiously?
Yes.
Right, and are you happy that really grounds 2 and 3 are both expressions of the same general point?
Yes. I've got my respondent's notice point on ground 3. I'll deal with that very briefly at the end. Because there is a difference.
Right, so heading grounds 2 and 3.
As you have the Network Rail case in front of you, the relevant paragraph is paragraph 18.
Say it again.
18, 1-8.
Thank you.
And you'll see it's 18.1 standard position to identify the intention of the parties by reference to what a reasonable person with background knowledge available would have understood. Also by focusing on the meaning of relevant words in the light of natural order and meaning of the phrase, any relevant provisions and so forth, including commercial common sense. Then subparagraph 2, a caveat in relation to commercial common sense mustn't be used to undervalue the importance of the language. And then subparagraph 3, when it comes to considering the centrally relevant words, to be interpreted clearer the natural meaning, the more difficult it is to justify departing. The less clear they are, or to put another way, the worse their drafting, the more ready the court can properly be prepared to depart from their natural meaning, and so forth. Commercial common sense not to be invoked retrospectively, and it's a very important factor, generally considered. Now, I say by reference to those, the following on the clauses, just taking a textual analysis. First of all, clause 3.1, if I may. At page
347.
Thank you, 347. Now, the point I want to make about this is, I say, the governing clause, or to use a property lawyer's term of phrase, this is the grant by the grantor. This is what I'm giving you. And therefore, you should give, on the face of it, this is the clause that matters if one's trying to work out what our rights are. It's the starting point. Not necessarily everything, but it's the starting point and the governing clause. The introducer shall be entitled to share in all, I emphasise all, management and performance fees, howsoever described, earned and received. I just pause on that for a moment, very important in context in the other matters. Received by Octave or any of its affiliates, subject to there being no double counting, in respect of each prospective investor who makes directly or indirectly an investment in a fund managed or advised by Octave for the current strategy on or before the cut-off date. Each such investment being an eligible investment. For the avoidance of doubt, additional investments made for the current strategy directly or indirectly into a fund whether before or after the cut-off date are also eligible investments. Now, what I submit first of all is the word all. That appears on its face to be entirely unequivocal. Secondly, this clause is obviously giving, on the face of it, very strong rights to the introducer. First, even after the contract has been terminated for 9 months, if someone comes in as a result of an introduction within those 9 months, Musst is going to get paid for that introduction. Secondly, in relation to existing investors, so if an investor is already there at termination, or indeed it would seem if they come in within the cut-off time, if they make a first investment, any subsequent investment at any time is called. So in other words, it could be 3 years later. The Crown could come in 2014, contract terminates, let's say, in 2015 or 16, Crown then make another investment in the current strategy in 2019. And I submit that what's intended here is if you get me in a good client, I'll give you 20% of everything, subject to the current strategy point. I'll give you 20% of what I get from him. And this is obviously what you might call a pro-introducer clause with strong rights for the introducer. The second point is, and I say the judge is right to focus on the word makes. On the face of it, that's it. The second point is clause 3.7. Now, what this, in my submission, is providing for, certainly two things, and the first thing is this, the judge's point. If, let us say, an eligible investment is sold, and the proceeds of that sale are used to buy an investment which is not an eligible investment in a new fund, then Must's rights cease in relation to that investment. They're entitled to a performance fee in relation to the eligible investment that's been sold as at the date of that sale. What it is not entitled to do is to trace into the proceeds in the new fund and say, oi, we want some of that as well. So it's providing, if you like, for an express cut-off point in relation to Must's rights. It says, once an investment gets sold and the proceeds get stuck into another fund, you don't get anything for those other proceeds, for any further accumulating profits. Now, this was a point the judge took, and in my submission, he's right to take it, that this is an express limitation on Must's rights, and a perfectly sensible one. I should mention one other thing that I say about this clause is this. Supposing, and it's the sort of thing that would happen, it does appear to happen, you might have an eligible investment which gets sold from the fund, which is, let's say, a current strategy fund, and then as a result of that, it's sold and the proceeds are put back into that same old fund following the current strategy. Now, it may well be the case that at that point, Astra will not be entitled to any performance fee because the money is being reinvested back into the same fund. It could also be that, let's say, a synthetic asset-backed security for 10 million has been sold at a great big profit, bringing in 15 million. It could be that that 15 million, for the sake of example, has been used to buy aeroplane shares. And it could be that the consequence of that is that the fund is no longer primarily in synthetic asset-backed securities. It would be, let's say, 3/4 aeroplane shares, 1/4 synthetic asset-backed securities. No performance fee would have been paid at that point to Astra or Octave, because the money was just put straight back in. Now, if that had happened, we don't know if it did. If that sort of thing happened, then in my submission, we would be entitled to say, in relation to the aeroplane shares acquired, that they were the proceeds of the original eligible investment, and we're entitled to treat that which have been put back into the old fund, and we'd be entitled to trace into those proceeds as well.
Okay,
now,
but that doesn't arise. I mean,
it doesn't arise in this
on the
case.
facts.
It doesn't arise.
Yeah, I mean, just one point I wanted to pick up on. I think broadly the effect of the Crown and 2B arrangements that I think we were taken to yesterday is, as I understand it, broadly performance fees crystallise when money comes out of the managed account.
Yes. Yes. Well,
which is, I think, consistent
yes.
with what you said. In other words, if you sell an investment and take money out of funds under management,
yes.
then that might crystallise it.
Well, there are two stages. You could take money out and it becomes cash, lurking sort of in the cash which is sitting next to the fund.
Yeah.
Now, as I understand it, certainly what appears to me is that the cash would often sit next to the fund and then be used by further investment. Right. Now, if the cash was then paid out, then it seems in those circumstances the performance fee would accrue. It's not clear to us, at least, whether performance. Certainly, all we know is we weren't paid any performance fees. But in any event, we say whatever the complications may be in relation to that, the one thing that is certain is we are entitled to be paid a performance fee in relation to profits made from the sale of what was an eligible investment. And that cannot be affected by the fact that 10 days or 2 months or 3 years or 2 years after the investment was originally acquired, the, quote, strategy changes in some way, if the investment is still there. And we say that would be entirely arbitrary. And it would expose our right, it would make our rights, which on the face of it look jolly good, pretty well meaningless. Now, the next point is clause 13.2. Now, the context of this is that it is a clause which applies after termination. Hence, as I think was pointed out yesterday, consequences of termination. Neither party shall have any further obligation to the other under this agreement after its termination. So that's the starting point. And the remedies specified in this agreement displace any other remedies. But then, 13.2, the introducer shall continue to be entitled to the revenue share in respect of all eligible investments as defined, for so long as such eligible investments in the current strategy are maintained by the investor, provided that, notwithstanding the foregoing, should this agreement be terminated following a repeated, after written notification, material breach of the introducer's obligations hereunder, including a sustained failure to comply with its obligations under clause 2.3, the right to receive revenue share will terminate. I make 2 points. First, point on the word order. I make 3 points, actually. The word order. It is important that what is said is for so long as such eligible investments in the current strategy are maintained by the investor. That is not the same thing as a matter of normal English, as for so long as such eligible investments are maintained in the current strategy. It just isn't. Now, you might say, well, what's the point of in the current strategy? To which we say, well, that's surplusage. Surplusage of itself does not mean you should put the words in a different place so as to give them meaning. On the contrary, you start from the premise, well, there's a bit of surplusage there. That, in my submission, is furthered or confirmed by the word maintained. Maintained by the investor means kept by the investor. So what it's focusing on is, for so long as you keep your investments, you will be entitled to your profit share. But once, of course, you don't maintain them with us, well, then you're not. That makes perfect sense. So first of all, I have my word order point. Secondly, I say maintained by the investor means just that. I might add, if it said maintained in the current strategy by the investor, that might be a bit odd, because very much, it's often, there's a lot of discretion, in fact, left to Astra. So I submit again, this doesn't fit with what my learned friend's asking. And it's certainly not very clear if it is. My learned friend has to say this is clear. It clearly contradicts clause 3.1. It clearly limits clause 3.1. I submit it doesn't do that at all. It may raise a question. I need to think about that. The second point,
the judge goes into this in considerable detail at 422, doesn't he?
He does.
I mean, you're not having to make this case for the first time.
No, I'm not. Well, my lord, can I just make one other point, which I'm not sure the judge does make, is this. It says that the other thing about this clause is the strength. It's basically saying you're going to be able to keep your profits even if you breach the agreement afterwards. In fact, you're only going to lose your right to them in the event of a repeated, after a written notification, material breach of the introducer's obligations. So this is all part of a very, what you might call a beefing up of the introducer's rights. In those circumstances, it's very odd to say, well, you've got these very strong rights. You can, and unless you're incredibly naughty, you're not going to lose them. But by the way, you might lose all of them tomorrow if the fund ceases to follow the current strategy. It's a bit like being suspended. Let's say you're at school, you're suspended for 3 months on the basis you've behaved incredibly badly. And then later you're expelled on the basis you didn't do your shoelaces up. And you say, well, hang on, what's that all about? Oh, I'm afraid to say, they've got two quite different rules, Bad behaviour gets you suspension for 3 months, but not doing your shoelaces up, you're out for good. That's effectively what my learned friend is arguing for. A swinging hidden right amongst what appears to be a very strong protection. Clause 1.1. Current strategy. Funds. Now, one of the problems with these definitions is they're quite circular and a little bit puzzling. They're sort of people who say for the avoidance of doubt, they're going to say something you were more doubtful after they said it than you were before. But anyway, funds. The Astra Special Situation Credit Fund Limited, that's Astra, and other funds and managed accounts designed to substantially replicate the investment securities and risk profile of Astra, and following substantially the same strategy as set out under the current strategy below. However, howsoever structured. Pause there and understands that bit. The really important words are the ones coming up. Established, or if not established, for which advance marketing activities are being undertaken on or before the termination date of this agreement, to which octave or manager acts as investment manager. It is understood for the purposes of interpretation of the definition of a fund that the strategy remains substantially similar to the current strategy. Now, what I submit, the context of the tail end of it, is this. It is talking about, what this clause is talking about as a whole, includes funds that are going to be set up in the future, and in particular funds that aren't even set up as at the date of termination, but there's still active marketing going on for them. And what that is providing, which of course the rest of the contract allows for this, what it is providing therefore is saying, in their case, in the case of these far-off, distant future funds, which haven't even been established at the date of termination, then in their case, the definition of current strategy remains the same. That's essentially what it's saying in my submission.
Sorry, when you say not established at termination, is that because you're reading the words in parenthesis as covering things for which advanced marketing activities have been undertaken?
Yes. Yes. So it's envisaging that what could happen is that at the date of termination, there's quite a lot of, we've got pretty far towards getting a new introducer in, but we haven't yet got him in, and then he comes in only afterwards. That's what it's envisaging. And in my submission, it is that element of futurity, if I can put it that way, in this clause, which explains the use of the word, which is the word my learned friend relies on, remains. It's basically saying the definition will remain the same throughout this agreement and afterwards. And one can see why the draftsman might have wanted to provide that.
Sorry, I don't think I've completely understood that. What does remains, which is a word in the present tense, mean in your...
Well, it means in practice is, but the reason why the draftsman is using remains is because he's saying this definition remains to be the definition, even for funds set up in the future and a long way off in the future.
It doesn't say the definition remains the same, it says the strategy remains.
Yes, I agree. But in my submission, what this is getting at is the strategy, the current strategy remains the same, or the definition of current strategy. My lady, I agree that this is a clumsy clause. The judge found essentially what I have said. He said the strategy is still. But in any event...
So what paragraph is that?
My lady, I did have it. Can I just come back to it? I'm sure I'll be given the reference. But in any event, I submit that is... The first point I make is this is a very obscure clause, and the judge certainly made this point. This is not a sufficiently clear clause to override the clear rights which are granted by clause 3.1. And indeed, I say 13.2 and 3.7. This is an obscure part of the clause at the tail end. And this, it would be wrong to allow what you might call an obscure part of a definition clause to override what appears to be the clear express words of grant in clause 3.1. But you have my explanation that this is essentially saying that the same definition applies for all funds, both those which are set up now and for those which are set up in the future. I mean, it's a very odd sentence, apart from anything else. It is understood for the purpose of interpretation of the definition of a fund. It's seeking to explain what a fund means, or is to be defined as, but then goes on to say something which is quite difficult to understand.
Okay, I think I explained what I.
Well, my lady, I was going to adopt that too. That could also be it. It remains
it's just
as
a
that.
statement of what the strategy currently being conducted.
Yes, well, my lady, that's also an alternative explanation. One of the difficulties with this is, of course, it is so obscure. But that is a perfectly sensible explanation, and in my submission, far more sensible than the explanation which my learned friend comes up with, which is saying, no, what this is providing for, so to speak, in a hidden part of the contract, or a definition part of the contract, that if there is a change in the current strategy, even after 10 days or 20 days, you lose all your rights in relation to investments already made. That is an astonishing conclusion. And commercial common sense is important when you're looking at what you might call sub-clauses, or clauses which are not the governing clause. Where in my submission we expect, if I can use the word derogation from grant, the derogation from grant normally has to be clear, so the draftsman knows what's going on. And my ladies and my lord, you'll remember in the, I think it was the insurance case which went to the Supreme Court in relation to the COVID insurance cases, they talked about, well, you look at the governing clause, that's what the insurer would expect the cover to be their X. But then the insurers are relying on clauses sort of page 98, as it were, saying, oh, but look, all that was qualified by what was on page 98. Their lordship said, well, that's not good enough. You look at what the businessman would understand from the governing clauses, not what the lawyer, drawing attention to page 98, would say, oh, but see, there's a qualification there, which effectively makes the grant virtually worthless. And my lady, I submit it does make it virtually worthless, by virtue of the sort of example I gave. A change in strategy after a huge investment, a month or two afterwards, when there's been little increase. Now, on the point about commercial common sense, I'd like to say this. First of all, it is obvious that if performance fees are a long way off, it is even more extraordinary. 3 years is likely, 3 or 4 years. All the more extraordinary, because through this contract, there's depriving us, or putting us in a position of enormous risk of losing the entirety of them after an enormous amount of work to get the client in. That makes no sense. Second, as to my learned friend's point that actually the judge misunderstood the position, and the clause could be construed as allowing for an accrued performance fee assessed as at the time the fund ceases to follow the current strategy, I submit that's hopeless, with great respect, as a matter of law. First, that, what you might call accrued performance fee construction, must depend and depend only on an implied term. There's nothing in the contract that even begins to tell you that's what the intention is. Second, look at the express terms, I say, and you go first of all to clause 3.1.
Give us a list of the terms you're about to refer to. 3.1.
4.12. In particular, 4.12. I mean, it's unanswerable. I think I'm remembering. 4.5. And indeed, 3.2. Revenue earned. When is revenue earned?
That's right. I wasn't trying to stop you taking us to each of them and commenting on them, just to see where we were going. So
yes.
Okay, well, starting with 3.1.
Yes, I think I'm within time. Mr. Baldwin's going to have plenty of time. If I can go to 3.1, yes,
right, we've been there.
I'm sorry, I'm just looking for. Oh, it's the second line. Earned and received. Earned and received. That's what our right is. It's premised upon receipt.
Yes.
Secondly, clause 4. Well, I may as well on it. 3.2. What we're entitled to is, quote, a revenue share. Now, it's not quite so strong, but a revenue share suggests the share of that which has been received. .12. Octave, or payment of revenue share, this is perhaps most important, but it's actually the heading, payment of revenue share. Octave shall on request send a statement showing particulars, investments and so on, the fees due and payable to Octave in respect of the previous calendar month, and the introducer's revenue share, and where such fees are invoiced by Octave, Octave shall provide a copy of the relevant invoice.
So all of these terms refer to receipt and shares.
Due and
Of
payable.
receipts.
Yeah. 4.5. Amounts payable shall be paid by manager within 10 days of, guess what? First receipt. Receipt. It's not some sort of time notional earlier. So I say, well, look, that's clear. Express words make it clear. Our rights arise upon receipt by Octave. It follows that we have no right to a notional performance fee at all.
No,
They've not received it.
if you'd asserted it, then that's what you'd have got in reply.
So what on earth are you talking about?
Right. Got that point.
Second, there is nothing here, as you would have expected, if there really is going to be some sort of notional performance fee. There's no method set out as to how to assess what that fee is for. No way of assessing it. There's no reference to an expert to determine the point. And this is important, my lord and my ladies, because these assets, no one is supposing these assets are traded regularly on a daily basis on the stock market, where you could easily find out what their value was at a given time. How on earth do you assess what the relative value is, or the value of what you might call very
hard to value assets.
very hard. No ready market against, no benchmark, no market against which to assess the notional performance fee. And then we also say the premise of clause 3.7 appears to be, again, receipt. Talks about amounts deriving from eligible investments and so forth. So, my lord, that's what we say. The other point, my lord, my ladies, is with respect, we do not understand where the point was made to the judge that accrued performance fees was a basis for assessing Must's entitlement in the event that the fund ceased to follow the current strategy. We've looked everywhere. We cannot find the point being made at all. You can do a little word search for accrued, going through the various bundles of things. It never appears. This is a totally new point. We respectfully say, I'll leave it to Mr. Borden to explain where, in terms, it was put to the judge that what he should be looking at was the notion of an accrued performance fee being payable as at the date the funds stopped following the current strategy, as an explanation.
Oh, sorry,
for what
Mr. Baldwin, I think it says it's not paid then, it's paid when the fees are received.
he does say that, but the notion of an accrued performance fee, as it were,
Yes, you say that notion wasn't put to you.
wasn't put, and we can't see it anywhere with respect.
Well,
Maybe
I'm just fishing around. Does paragraph 58 of the judgment touch on this? Because that I think is what is relied upon.
Well, no. If that was what the judge was thinking, it was not because of any submission put to him. If we go to paragraph 58, is it 58, my lord? 558 is it all? My lord, sorry, I've lost the reference to the relevant part of the judgment.
Yes, well,
there was a part of the judgment.
It's not 58, but the reference in I'm looking at the skeleton argument. Which refers to that paragraph. Paragraph
My lord, there was a
7
yes
of the Respondent skeleton argument in response to the second appeal. I have it at 49.
My lord, there was a paragraph which I think was a subject of discussion yesterday, actually, where it was suggested that maybe the judge had this point in mind, given the way he expressed himself. I think Lady Justice Falk actually drew attention to it.
All right. Well,
But
it just appears on a word search to be a reading through to the judgment at some point.
my lord, can I just say how the case we certainly understood was put in the defence? I'll just show you one reference, but I'll give you all the other references. In the defence and counterclaim, if you turn to the core bundle, page 430.
Just to bookmark it before we leave this point.
Yes.
The paragraph to which reference was made is in fact at 526
I'm obliged.
of the bundle and 58 of the judgment.
Or is it the second judgment?
Yes,
Ah.
it will be.
Oh,
Oh, well, my lord, yes, but that's different, because by then the point was being squarely taken in relation to the fund. But in the criticism my learned friend makes of the first judgment is that the judge doesn't take into account his accrued performance fee argument. As I understand it, I might be wrong about that, but my point is it was not, certainly not clearly, put to the judge at the trial, the main trial, and before he gave his first judgment.
I see.
But the way round the harshness of the construction for which Astra was contending was to say...
Right, so you would put it, launched that argument after the event.
Yeah, absolutely. That's part of my response to this. There's a different point. But this argument we're on now, the judge is criticised for not taking into account the accrued performance fee argument in his first judgment. We say, well, first of all, it's a bad argument. You have that. But secondly, not very surprising. Can I just take you to one reference and then give you other references so you can, not now, look at them, but so you can see why I say this wasn't certainly not clearly put to the judge and therefore cannot found proper criticism of his judgment. The defence and counterclaim, in the second part of the core bundle, at page 439, says, I thought I had the right record. 430, it must be 430.
I think it may be 439. But it's
Oh.
certainly there as well.
No, my lady, I was on a different point, but not sure. That's on the November arrangement, but perhaps I could just explain the context. The second main part of the defence was that even if the octave contract applied, and the November arrangement didn't, nonetheless we were entitled to nothing because the two funds had ceased to follow the current strategy. That was part two of the defence. And that begins in its summary, or rather in the pleading, not in the summary. That begins at page 426, para 183, alternative case. The position under the octave contract and new investments, which were not within the current strategy. So basically, they say, from 183 to 193, even if the octave contract applied, you're not entitled to anything because the current strategy had ceased to be followed by the time we then set the whole position out. I don't invite you to read all of it. I just invite you to read the conclusion.
193.
193.
Right.
Nothing due to you.
That was the case at trial.
That was the case at trial. That's the case that the judge deals with in his judgment. Therefore, to criticise the judge in his first judgment for not taking into account the argument which wasn't run, namely on the cessation of the current strategy and accrued performance fee became due, I submit is wholly unfair. I have gone through the pleadings, every single document we can. Pleadings, the evidence, the transcripts. We cannot see anything where the point is made accrued performance fees fell due upon the cessation of found strategy. Nothing. Therefore, to blame the judge for not dealing with the point, I submit is not fair. And it can't now form the basis of the complaint. One final point. You have my point that none of this makes commercial. None of this is provided for by the contract anyway. I should add, it makes no commercial sense for the reason I gave at the beginning. It means Octave get the benefit of the rise in the fund, in the rise of the investment, but if it goes down again, oh well, we get nothing. It's not really an accrued performance fee we're entitled to. We're entitled to an accrued performance fee as long as the value of the investment doesn't go down. My lord, where does that appear in the contract? I mean, this is sort of fanciful. So that's what we say. The next point, that's ground 2. We say nothing in it. Ground 3, and the judge got it absolutely right. Everything he says is spot on. Ground 3 is a very similar point. This is a point that the 2B and Crown accounts ceased to replicate the Ascaful fund. It's a slightly different point from the current strategy point. What they're saying is, even if they did continue to follow the current strategy, nonetheless the Ascaful fund ceased to exist, and therefore, ex hypothesi, Crown and 2B funds ceased to replicate the Ascaful fund because the Ascaful fund wasn't there to replicate. Ergo, no fees, even if Crown and 2B continued for 5 years to be solely invested in, let's say, synthetic aspects. That's the argument. On the face of it, my lord, you've seen, my lord, my ladies, you've seen the contract. Where on earth do you get that from? And the answer appears to be, as with respect what we make out, it goes back to what one sees at in the definition of funds. Now, the argument run at first instance was that as soon as Ascaful ceased to exist, there was no fund to replicate, and that was in 2014, 2015. There was no fund to replicate, therefore, ex hypothesi, the necessary condition of a fund to replicate ceased to be there, therefore we were entitled to nothing. That was the case run at trial. That particular point, the judge didn't actually deal with this judgment. And neither party picked it up in the comments on this judgment. So the defendants didn't pick it up, we didn't pick it up. And I have to admit, I just totally forgot about it from my part. But anyway, neither of us picked it up. And so the judgment goes out as in the draft without dealing with this particular point, that nothing was due because the fund had ceased to exist, the Ascaful fund had ceased to exist, as at December 2015. There's nothing in the judgment. What happens afterwards is after the judge has given his judgment, the judge in his judgment says, well, I think it's appropriate to make an order for an interim payment, but I'll need to have some information about it as to what that should be. And so a month later, we come back with some information having been provided as ordered by the judge when handing down the judgment. And at that point, Astra put forward, they give certain information, and they say, look, there are two possibilities here for the interim payment. One is about 3.8 million, which we accept is there, because we accept that's what the fund consists of by reference to eligible investments, on your definition. But they then go on to say, but there's an alternative which they prefer, which should be something more like 2 million, thereabouts. That is on the basis, they argue, that there was a cut-off date, that as at the cut-off date in December 2015, the fund had ceased, as they previously argued, to replicate. Crown and 2B had ceased to replicate the Ascaful fund, but what the court could do on a proper construction contract was to order an accrued performance fee by reference to the value of the Crown and 2B funds as at December 2015. That, my lord and my ladies, is the first time this notion, so far as we are aware, ever surfaced. And it surfaced in particular and only in relation to the argument about the replication of the fund. The judge then deals with that argument and that argument alone in his second judgment, the consequential judgment. That is now ground 3 of the appeal. And what we say in relation to that is all the same things we say in relation to ground 2. That is to say, it suffers from the same problem, that it is inconsistent with the terms of the contract, which all provide for must's rights to arise upon receipt. We say that's the short answer to it. We do also say that it is very difficult, a slightly separate point, one of the other points that is relied upon in relation to ground 3 is clause 3.7. Perhaps I should take you to 3.7. Now, this is a point which is specific, really, to ground 3. And they, parties hereby agree, any new investment and so forth, deriving from a redemption following the current strategy, will not be treated as eligible investments. It's the new fund point. And then, the important words, this ground. And this includes a restructuring of ASCF to turn into a liquid, open-ended fund following. Brilliant drafting, you might say. But anyway, what does that mean? Now, what Astra say is what that's getting at is the notion that there can be a restructuring of ASCF and to turn it into a liquid, open-ended fund. And at that point, it must be the case that a performance fee could accrue to Musst. In other words, just a mere quote restructuring would do the job. And that's being prayed in aid of the construction generally, that we will get something upon ASCF ceasing to exist. Now, first of all, it's just not there. And the whole argument is inconsistent with all the other clauses. But secondly, what does this mean? And this includes a restructuring of ASCF. In my submission, a restructuring is most likely to take place when there's been a sale of all the assets. The investors then get their money, and then it's reinvested into another, different fund. And in context, I submit that this is obviously what is being spoken about by those rather obscure words. That's the proper construction, and this includes restructuring, because and this includes is talking about the reinvestment of funds deriving from the redemption of investments originally made in a fund. The whole context of this clause is what happens when assets are sold and proceeds are received. And if they're put into a new fund, then the fund, you're entitled to the performance fees, which will be payable, but you're not going to be entitled to performance fees from the profits of the new fund. And likewise, it's saying the same applies in relation to a restructuring of ASCF. So if ASCF gets restructured, the investors get their money back, or the investors, Crown makes a lot of money, Astra make a lot of money from that, Crown makes money and Astra make money. Then, in those circumstances, Musst will be paid out the 20% share, but it won't have any interest in the future profits in the new fund, in the restructured fund. In other words, your rights come to an end upon the sale of the assets in the ASCF fund. They won't continue into the proceeds of the new fund. And that fits with the entirety of the clause. It's badly drafted, but that, in my submission, is what it's getting at. It's not getting at some sort of notion that we're entitled to an accrued performance fee as at the date of the, quote, restructuring the fund. And my lady, one of the strange things about it is there's absolutely no way of determining what a restructuring of the fund means if this is such an important event. in many respects, is more of the same in relation to this ground as in relation to the other. There is, however, one further point, and this is the one that gives rise to our respondent's notes. I'm going to finish in 10 minutes. If this point was to be taken at trial, we most certainly would have wanted to put some evidence in. And that is dealt with in paragraphs 20 to 25 of our skeleton, in opposition to this ground and in support of the respondent's notice point. And perhaps, can I just take you to that? It's core bundle 2.
Your second.
Yes, it's our second skeleton. It's at 496, where it begins.
Sorry. And where are you in the paragraphs 20?
The relevant section, if I can put it that way, dealing with this point, what I call the respondent's notice point, begins at paragraph 14.
Thank you.
But the actual bit which I particularly want to rely on begins at paragraph 20. And what we say is, if this sort of argument was going to be run at trial, it had to be in the defence, and it plainly wasn't in the defence. And what we say in paragraph 20 is that they're in reality seeking to resuscitate, in different guise, a variant of the original cut-off argument in relation to the replication of funds point. It couldn't reopen the original one. That was common ground. It can't do it in a new way. But then we set out paragraphs 21 to 24. We set out what we would have wanted to plead and put evidence in, if necessary, and to cross-examine on. By reference to the points that Astra itself make in support of this argument. We're dealing with point in paragraph 21, Astra say in terms. Their cut-off point is right because we knew certain things. We say, well, we would want to put evidence in on that. You can't say my argument is right because we knew certain things, and you didn't plead that, and you didn't put that to us. It's obviously wrong. Secondly, that's paragraph 22. We say we would have wanted to plead and adduce evidence and support to show what the parties had in mind by, and this includes a restructuring of Astra. That was something which, with such an obscure phrase, a party would be entitled to give evidence of the factual matrix in the background, as to what all that's about. But we didn't need to cover that. Next, the argument against us is that Ascafil's restructuring couldn't be manipulated by Optive, given their investment criteria, the need for shareholder consent. Well, okay, that may or may not be the case, but we'd be entitled to challenge that at trial and go into it. And then we would have wanted to produce evidence in support of an estoppel. The parties didn't begin to operate on that on the basis that once Ascafil ceased to exist, we weren't entitled to anything. We certainly would have wanted to say something on that. And we're entitled to a performance fee. And so we just say this is all far too late. And that's the respondent. There is some authorities we rely on. Can I just take you to one? Glatt and Sinclair, Court of Appeal decision, at paragraph 24.
Tab 9.
I think so, my lord. I think, my lord, from recollection, it's paragraph 25, which has the relevant citation. And this was a case where I think after this is a case essentially dealing with, I think, attempts to raise arguments after judgment has been given, and the difficulties that gives rise to it. Now, of course, you can do it on an appeal, as long as it requires no further evidence. So the passage I just want to rely on is paragraph 24 down to 26. These are the principles. You don't really need to go beyond 24, actually.
Go beyond Patalis and Grant?
No, it's just a summary of Patalis and Grant.
Right.
Thank you for that. It's considerably longer. I originally put it in, but I thought, well, because of the rule, I better take it out. But it is basically Patalis and Grant. There is a fact which I'm not going to ask you to read, but there is some recent first instance authorities which have considered this in the context of amendments and indeed applications to make new arguments after trial. And I think that one is Kensel and Curley, which is in the bundle. We have the reference in the skeleton. Yes. Paragraphs 47 to 53 by Mr Justice Zaccaroli. And there's paragraph 18 gives the references. Essentially, paragraph 18, perhaps the simplest thing to do is simply look up paragraph 18 of our second skeleton argument on page 504. It gives you the references to the relevant authorities. Essentially, we say this is a Henderson. My learned friend quite rightly says I didn't use the words abuse of the process or Henderson when this point first arose, but we certainly complained about it. We said it was too late. So in other words, we made the point. We didn't dress it up in the language of abuse of process, but we certainly took the point. And in his judgment, the consequentials judgment, the judge says, I don't need to deal with it. So, my ladies, it may be you don't need to deal with it. But lest you think there's anything in this third ground, I submit it's not open. For the reasons I've given, and in particular in the light of the authorities at para 18, which do consider this type of problem. My lord and my ladies, unless there's anything further, those are my submissions.
No, thank you, Mr. Knox. Thank you very much. All right, Mr. Boardman. Well, if we could have an eye on that's for this building, that clock's not too bad. Roughly right. If we could have an eye to rising a little bit before 4 o'clock, please. Thank you.
Ladies, my submissions might be slightly staccato, but hopefully they will cover the main points that the learned friends made in my response to it. As far as I'm obviously not going to repeat the submissions I made in opening, because that's not going to assist you at all, and given the time, I won't be able to do that. Let me first just deal briefly with what I call the evaluation point. My learned friends seem to suggest that the appeal on novation was purely a question of evaluation. I hope that during the course of my submissions and opening, I went a lot further than simply criticise the judge for his evaluation of the evidence. My submissions were as follows, and are as follows, that the judge failed to apply the correct legal principles, which he correctly identified in the judgment, to the facts of the case. Secondly, that he misunderstood or failed to take into account the contractual background to the alleged novations, in particular the distinction between manager and investment manager and the liability. Thirdly, that he failed or misunderstood the invoicing process, and in particular the disparity between the contractual position and the invoicing process. And given that he relied fundamentally on the change of invoicing, that was particularly important and particularly relevant for him to take into account. Finally, also that he found what I would describe as an unpleaded bilateral agreement, which was unsupported by consideration. Then he wrongly construed clauses 16 and 17. Then he failed to consider the limited basis of the UK novation and found an estoppel when it wasn't pleaded. And indeed, he relied on what he himself described as a bolt-on estoppel that would have added nothing to the novation argument anyway. So those are in brief my grounds on the novation point, and they don't simply go to question of evaluation. The question for this court, in my respectful submission, is simply whether the judge was right to find that there was what he described. I accept he did use the word novation, and I hope to persuade you that in fact he didn't find that there was a novation. And this is indeed exactly the approach that this court took in the Tichy case. Very briefly, I'll give you the reference, if I may, to the Master of the Rolls judgment. Paragraph 19 of Lord Phillips' judgment. Our primary task is to decide whether the judge was correct to hold that the novation alleged to have taken place did not occur. And that in a nutshell, is the same issue that is before you. It wasn't and wasn't considered by the Court of Appeal in the Tichy case some sort of evaluative judgment to which principles of discretion might apply. The court was perfectly able to look at the documents, decide for itself whether or not they amounted to a novation as alleged, and I invite you to do the same. And so that's the evaluation point. Next, the background point. My learned friend took you through a lot of documents this morning, but in my submission, they didn't support the submissions that he was making, that there couldn't be any other explanation but a transfer by way of novation. Let me first, if I may, turn to the 15th of August 14 letter. Now, I did make some submissions on it, but there were some exchanges this morning that I would just like to add to, if I may. It was suggested by my Lady Justice Falk that perhaps there was an error in the drafting of that letter. And when it referred to the obligations, it was referring to the obligations of LLP. And that was on the second page of the letter. So let me just go to it.
Well, I'm not sure I go that far. I didn't mean to. I was pointing out.
Might have been.
That it refers to.
You raised that with my learned friend.
Yeah.
I don't think he accepted this.
We have the letter in front of us.
Yes, sir. It's page 184 of the supplemental bundle. In my submission, far from supporting any suggestion that there was a novation of the entire right and obligation of the Octave contract LLP, this says something quite different. What it says, this is on page 185, Octave LLP hereby confirms to Astra LLP that one, subject to parties agreeing, it's our intention that the investment management services will transfer to Astra LLP. So that's the performing of the services under the 2B and Crown contracts. I agree with that. However, number two, that any fees or obligations will transfer to Astra Capital. So it's a case where it's clear from this that Octave LLP will not be taking on any obligations. It doesn't support the opposite proposition at all. It certainly doesn't provide any background to suggest that Astra LLP was taking on all of the obligations, and that Astra Capital, as my own friend repeatedly said, had absolutely nothing to do with it. It doesn't support that proposition at all. In my submission, the writer was well aware that the obligations were with Limited, not with Octave LLP, and therefore they wouldn't transfer to Astra LLP, they would transfer to Astra Capital. That's exactly what the draft agreement then provided for. So that was what was not only provided for in the agreements between Octave and Astra, but it was also what came across the line from Astra to Musst, and it was also reflected in the change in the prospectus of the master fund, namely that it would be Astra Capital taking on the role of manager, and it would be Astra LLP taking on the role of investment manager. The simple point that I re-emphasise is that to take on the services under the 2B and Crown contracts does not imply with it that you're taking on all the rights and obligations under the Octave contract. It just doesn't follow. So that was my submission on the 15th of August letter. Then on clause 3.6 of the contract, my own friend seemed to accept that there was this separation of roles between the manager and the investment manager under the terms of the Octave contract. But then he submitted to the court that what Octave Limited was doing under clause 3.6 was discharging LLP's liability. That, of course, is not the case. It has its own obligation, and it's the sole obligor. That's what that clause provides for. If the liability had been that of Octave LLP, well, then I can understand the argument that by transferring that role to Astra LLP, there might go with it a transfer of the obligation. But because that obligation didn't belong to Octave LLP, there was no basis to make that connection. So in my submission, there's no warrant. When you consider the invoicing, when you consider this letter, and when you consider the terms of the contract, there's simply no warrant to say, well, it was obvious that what was going on was that LLP was taking on everything under the terms of the agreement. And I remind the court that what needs to happen is there needs to be a very clear evidence that that is what the parties intended. And one cannot say, just from the various ways in which this has been pleaded, the various ways it was put to the judge, and in fact, when the judge actually came to his conclusion, the different way in which he interpreted that was unnecessarily the case. Then my learned friend relied on the fact, and I don't dispute the primary fact of this, that there was a possibility of the transfer that was discussed. And he referred to clause 9.4 in that regard, as the judge did, as I showed the court yesterday. That is absolutely right, but in my submission, the court's got to look at all of the provisions of the contract. And where the parties have agreed that if there's going to be a change of obligor under the terms of the agreement, it needs to be done in writing, signed by the parties, then that must be given effect to. That's the Rock principle. I'll deal with that in a little bit more detail in due course. The parties, therefore, were conscious of the need for formality. They can be taken to be aware of clauses 16 and 17 of the terms of the agreement. And indeed, Mr. Murray clearly was, because he produced a draft agreement that would give effect to that formality. The problem with that was that there was a delay on Must's side, and in the end, that agreement was never made. So the parties were clearly aware of the need for formality, and they didn't waive it in any sense. Nobody said anything about that. In my submission, the draft agreement that Mr. Murray prepared crucially shows that there was no desire to novate, because what was being suggested, as he made clear, wasn't a novation, but simply a change of agreements with effect from what he described as the effective date. That still left in place the earlier agreement. That's what he explained to Ms. Gallagher during the course of their telephone exchanges. What that draft agreement also shows critically is that there was no willingness of LLP to take on the rights and obligations under the Octave agreement. On the contrary, at best, it was only willing to step into the shoes that had previously been occupied by Octave LLP as investment manager, and of course that did not involve the taking on of all the obligations. And the last part of that jigsaw is Astra Capital's willingness to take on that obligation. Astra Capital was willing to do that. It made that offer some week after the second, I think, agreement was made, and so there was no breach of clause 9.4, not that the judge found that there was one in any event. I don't think there was really any evidence on the point one way or the other on that. My submission was, and still is, that if you don't mention a clause, you don't make any allegation of breach of a clause, you can't then turn around and say, well, I waived my rights under that clause, because silence won't waive any such right. Indeed, if
Sorry,
that,
just in the same way that you say the parties must have been taken to have been aware of clauses 16 and 17, presumably that applies to clause 9.
absolutely, I accept that the parties would have been aware of clause 9.4, but what I say is that that was fulfilled, at the very least, by Capital and Astra LLP making the offer that they did.
Okay, even though they did that after
yes, the
the
timing.
business had transferred.
Yes, well, the business being the business of the services that were under the terms of the 2B and the Crown contract, not the business that was the business under the terms of the Octave agreement, because the Octave agreement at that point, milady, was nothing more than a liability. I mean, there were no introductions being made at this point by Must. Okay. It wasn't an operative agreement in the usual sense of that term. There wasn't a transfer of Octave's business to Astra LLP in the way that has sometimes been suggested. I accept that there was a transfer of the contracts, the two being Crown contracts, in the way that I've shown the court. And I also accept that as a result of that, Astra LLP did stand in the position that had previously been occupied by Octave LLP as regards invoicing and paying. But it doesn't go, the critical point is, it doesn't go any further than that. So my learned friend also sought to persuade you, by reference to the submissions, record of his submissions, that the judge had found that there was an agreement for Octave Limited and LLP to drop out of the picture, and for both of those functions to be taken on by Astra LLP. Everything I've just been submitting shows that that is not correct. And when I read paragraph 379 of the judgment, which is what my learned friend was relying on in that regard, I didn't find such a finding either. So in my submission, there was no basis for the judge to infer or assume that Astra LLP was taking over everything under the agreement. Then let me deal with the question of agency, if I may. My learned friend correctly said that it was neither pleaded nor proved that Astra LLP was occupying this role as an agent for Octave. That's simply not part of Astra's case. And the significance of which there is none. It was operating on its own account, but the offer that it was making through Mr Murray, together with Astra Capital, was the one set out in the draft agreement, which wasn't finalised. And so we're left with a position where it was simply invoicing or asking for invoices to be addressed to it and making payments. And that's really the beginning and the end of this whole argument. And I've already made my submissions as to the limited inference that one can draw from that. Then my learned friend referred you to the emails that passed between Mr Holdham and Miss Galligan, and then Mr Murray and Miss Galligan. My submission in summary is that the Holdham emails really just deal with the question of invoicing and payment, nothing more. That isn't substantive in this context, particularly when it comes to liability, for all the reasons I've been submitting already. Mr Murray's emails, on the other hand, were clearly substantive because they did clearly affect and were intended to affect the legal position that previously existed between the parties. However, he was clearly not acting in that regard for Octave. What he was acting for the Astra parties in putting that offer forward, an offer that wasn't in the end accepted. So that, again, cannot be found, in my respectful submission, some sort of novation involving Octave and a cancellation of one agreement and its replacement with another. In short, the offer that was being made through Mr Murray was a very different offer from the one that is advanced, and it is suggested by my learned friend on the basis of the judge's findings that that was simply recording the agreement that had already taken place. It wasn't recording that, it's a very different agreement.
There was an issue before the judge as to whether Mr Holdham was just invoicing, as you put it.
Yes, that's true.
And he found that that wasn't the correct evaluation of what he was doing. Did he not?
He did indeed, my lord. He said that it was in the context substantive, not merely administrative.
Exactly.
Yeah. And I challenge that, my lord.
Yes, well, I know you're challenging it, but what possible basis have you got for challenging it?
Because, my lord, I say that the legal obligation was with Octave Limited.
Yes, I know, but all you're doing
is
repeating arguments that the judge rejected. And, I mean,
yes, maybe that, to some extent, that's right.
Well, in that case, how does that help?
But I say the judge misinterpreted that because in the Octave contract itself refers to the role of Octave LLP as being administrative and or operative. I was simply reflecting the wording of the Octave contract when I made that submission to the judge. In other words, I was saying that it's not substantive because it's just fulfilling that role that it was always envisaged that Octave LLP would perform. But the judge, I accept, didn't agree with me, and he said that it was substantive, meaning it did impact on the contractual obligation. But that is what I seek to challenge. Then my learned friend relied on the June negotiations, as I call them. This is really an attempt to retrospectively affect the court's mindset and bring into account matters which are post-contractual, were not pleaded as part of of the contract and really just show the parties' subjective understandings at a later time. They cannot form the basis either in my submission of a contract. Indeed, the judge didn't find that they formed any basis of a contract. So in that respect, my learned friend is departing and trying to rely on additional grounds. Nor can they themselves found any form of estoppel. There was no reliance placed on that. This was right at the end of the parties' relationship, at a time when, as you've seen, I think, from the documents my learned friend showed you, Mr. Martha was trying to reach some agreement with Ms. Gallagher and Mr. Siddiqui that would bring an end to their relationship. That didn't go anywhere, and the net result was that Astra didn't comply with the terms of the agreement, and then Mr. Siddiqui wrote his July email saying, you're liable, essentially. I don't accept that those exchanges in any event are necessarily predicated on any admission that UK is liable. Mr. Martha doesn't say that. There's no express reference to UK, LLP or any other party. It's just talking about the contract and the payments and the fees. So my learned friend submits too much in my respectful submission.
It might have been a shorter meeting if there was no liability.
I'm sorry?
It might have been a shorter meeting if there was no liability.
Yes, I'm not going to repeat all the submissions I made
okay.
before the judge. That was a snippet of a longer meeting. There was quite a lot of evidence on it, but the words of the transcript are the words of the transcript. As regards the 28th of July email, in my respectful submission, the important point is it shows the very opposite of what my learned friend suggests. He says and pleads that agreement represents the making of an agreement. Sorry, that email represents the making of an agreement, namely accepting an offer that had been made previously. In my submission, it shows anything except there being some sort of consensus ad item. What it shows is that the parties have fallen out and one is threatening the other one with a legal claim. In other words, it provides no evidence to support the existence of an agreement. Rather, it provides evidence to support a dispute. And again, this really is a retrospective attempt to find a novation where the only thing that had happened up to this point was that an invoice had been sent to LLP, and then Mr. Holdham said, can you address future invoices to UK? That's the beginning and the end of it. And that in my respectful submission, is very, very thin grounds, indeed, evidentially, to found any kind of novation, let alone an estoppel, and there's a separate point on estoppel, which I'll deal with in just a moment. Let me go to the bipartite point. There is no alternative claim for a bipartite agreement under the terms of the particulars of the claim. I showed the court what they provided for yesterday. What was alleged was an agreement between 4 parties, and what was alleged was a novation, albeit of 3 different kinds, taking on assets and liabilities, taking over assets and liabilities, or simply taking on the liabilities. No bipartite agreement, and certainly not an agreement in the terms that the judge found. The judge himself, I don't accept, although he did use the word novation, he did not find a novation, because a novation necessarily involves, as my learned friend showed you in Chitty, the extinguishment of other obligations, and necessarily requires, therefore, all the parties to the existing contract to be a party to that agreement. By its very nature, a bipartite agreement here cannot amount to a novation, but is something else. It can impose a liability, I accept, but it's not a novation, and it requires separate consideration, and hence the relevance of that point. In terms of the consideration, my learned friend submitted today that the consideration for the agreement was the giving up of clause 9.4 and the releasing of Octaves from rights and obligations. And the court will have well in mind that that is not the consideration that the judge found. And to some extent, that's not the consideration that my learned friend pleaded. What he pleaded was a classic novation, namely that, and because it involved all the parties, it involved the releasing of Octave from its rights and obligations under the Octave contract, and the replacement of those rights and obligations with a new agreement to similar effect. That's different from what my learned friend has been submitting this morning. And my submission yesterday, which I'll just repeat to deal with my learned friend's submission this morning, was that by simply agreeing to accept money, that did not amount to valuable consideration in law. Otherwise, any promisee could, by saying I will agree to accept a voluntary payment, furnish consideration for the promise of the payment. When one puts it in those terms in my submission, one sees that it's not valuable consideration. Let me then deal with the estoppel point. No estoppel regarding UK was pleaded. I showed the court that yesterday. My learned friend's attempt this morning to find an estoppel in a reply is hopeless in my submission. What he showed you in the defence and counterclaim was a repeating of certain other clauses that related to the novation and assignment to LLP. By repeating those clauses, what Astra was saying and pleading in its defence was that there was no assignment to LLP, sorry, or novation to LLP, either by way of agreement or by way of estoppel. It wasn't asserting that there wasn't an estoppel to UK. And what it was saying was that the intermediate stage of novation to LLP wasn't satisfied either. My learned friend cannot find in a repeat of that there was no novation to LLP a claim that there was an estoppel to UK. It just doesn't exist. And so if one then, even when one goes to the reply, and what my learned friend tried to find was some sort of a estoppel in a reply, even though you can't plead an estoppel in reply, I mean, that's basic right law.
My lord, my ladies, that is simply not right.
So you can't advance a claim in a reply. You have to amend your claim, as my learned friend well knows, because he did amend the particular claim, following the defence, to plead various estoppels, but he did not amend the claim to plead this estoppel. So in my submission...
Isn't that all water under the bridge? Because the judge found there was an estoppel.
Yeah.
So
Yes.
I mean, this has all gone by, hasn't it?
Well, it's right. I made it clear to the judge in our trial skeleton argument that there was no estoppel pleaded in relation
Well,
to...
so you might have done, but he has found in terms there was an estoppel
He
at both
did.
stages,
No,
hasn't he?
I entirely accept that. He did
There's
find
no
it.
ground of appeal about this.
I'm not sure, my lord, that is
Well,
correct.
show-
Certainly I intended to attack that.
Well, show us where in the grounds of appeal
Yes,
there is a challenge to that.
yes, I should do that. Ground one of the appeal was that the judge was wrong to hold that the agreement was novated,
Yes.
and further, for the same reason that there was an estoppel. So the estoppel is challenged.
I stand corrected.
Yes,
Thank you.
and I did take this point also, I believe, in the skeleton argument in support of the appeal. My learned friend is wrong to say that this point was not made at trial. It was made at trial. It's right to say that the judge nonetheless found the estoppel. But let me, if I may, also deal with the substance of it. I don't accept my learned friend's attempt to rely on a different estoppel. I cannot create something that never existed. What I do say is that the judge, if that point goes, that the judge was wrong to find an estoppel based on simply invoicing and payments for the same reasons that he was wrong to find a novation. That's essentially what the judge found in my respectful submission. And let me just draw that paragraph to the court's attention from the judgment. The judge was himself frank when he dealt with the question of estoppel, but it wouldn't have succeeded if the claim for novation was incorrect. And let me just draw that to your attention. That is page 2078 of the core bundle, paragraph 397 of the judgment, where the judge says this: it is unlikely that this adds anything to the argument, in that it is difficult to see the circumstances in which there would not be a novation by conduct, but the estoppel would still exist. In other words, if he's, the judge himself is accepting that if he's wrong on novation, then there wouldn't be anything to support an estoppel. And when one looks at paragraphs 398 through to 400, one can see very much why that was the case. Because
you could put it the other way around, actually, couldn't you? You could start with estoppel conceptually and say, does this have the makings of an estoppel, and I think the building bricks are all in the judgment, and it feels to me in a way as if you could then work backwards and say if there's an estoppel by convention, then where does that leave you on the novation?
Indeed, I accept that, and what the judge has relied on, in fact, because this was the basis on which it was pleaded, the very same things that found the novation, found the estoppel. And what the judge was saying, and I understand in that sentence that I just read out, is that if it fails on novation, it fails on estoppel. In other words, doesn't add anything to the estoppel argument. Or you could put it the other way and
I
say,
suppose what I'm putting to you is, could it go the other way? If you succeed on estoppel, do you necessarily succeed on novation? Oh, sorry, if must succeeds on estoppel, does it necessarily succeed on novation as well? Probably does by the judge.
That's what the judge found. That's what the judge found.
They stand or fall together. Put it
that is the way I put it. Absolutely. So that's estoppel. Let me then turn to clauses 16 and 17. It's unquestionable that a novation, that is to say, the taking over of another person's rights and obligations under an existing contract, involves the release of the former party's rights and obligations. As I think my learned friend said, their extinguishment. The learned friend sought to persuade the court that that does not involve any variation or a dealing with those obligations. And when one puts it just in those simple terms, one sees that it's just wrong. It's both a variation and a dealing with those rights and obligations. One can see that from the set case, which I drew to the court's attention. Because as you may recall that I referred to paragraph 35 of Mr Justice Gloucester's judgment, where she said that the no novation or assignment clause would prevent a novation in this case. Let me just, to make that point good, refer you to that.
Tab 4.
It's in the bundle of authorities, tab 4. The terms of the clause are in paragraph 25 of the judgment on page 61 of the bundle. And you may think, Lord and ladies, that the terms of this are not very dissimilar from clause 17. Namely, that the parties, none of the parties will be entitled to assign, transfer, or otherwise dispose. So the difference is dispose as opposed to deal with the distributor agreement without the prior written consent of the other parties. So that's very, very similar terms indeed, clause 17. And what the judge held in paragraph, sorry, I said it was 35. I think it's 37. In my judgment, there is nothing in the evidence which supports either a waiver of the requirements of clause 7.4 or any estoppel which precludes stemming from denying the alleged novation and assignment. And the learned judge then refers to the Linen Gardens case, which establishes that where there's a contractual prohibition, then the effect of not complying with it is invalidity. So my learned friend took a number of points on clause 17, all of which in my submission were wrong. First of all, he said that they wouldn't apply to clause 17, and that's wrong, as we can see here. Secondly, that it wouldn't amount to an invalidity, which is wrong again. Thirdly, that the reference to needing the other party's written consent meant that it could be waived. And in my submission, what it would require is both parties to agree. Because when one's dealing here not with an assignment, which might require one party to agree, where it's a voluntary act by another party, but we're dealing here with a novation. A novation necessarily requires both parties to agree. And not only to agree, but in accordance with the terms of clause 17, to record that in a written agreement. That's
It says written consent.
Yes, indeed. Indeed. So I submit to the court that a novation necessarily involves both a variation, because you are bringing an end to the existing rights and obligations. Necessarily that involves a variation. And also it involves a dealing.
Sorry, I missed that last bit.
It also involves a dealing.
A dealing.
Yes, so variation is clause 16 and dealing is clause 17. Just one final point on this. My learned friend sought to rely on Rock for the proposition that it is possible, and he went further and said, clear here, that there would be an estoppel that would allow must to get around the clauses. And for these purposes, it makes no difference whether you're dealing with Clause 16 or Clause 17. They're both contractual prohibitions, and they have to be complied with. And if they're not complied with, then the result is that the dealing is not necessarily, as was explained in the Rock case, a breach of an agreement, but it's simply not of any legal effect. That's what the parties have agreed. What Malone Friend relied on from the Rock was the passage right at the end, after confirming that they will be giving effect, right at the end of Lord Sumption's dealing with this particular point, paragraph 16, where he said, Malone Friend read out the relevant bit to you, so I won't do that, but then that it would require, at the very least, an unequivocal representation that the clause, the variation was valid, notwithstanding informality. In other words, there would have to be a representation that the party is not relying on that clause. And there was no such thing here. I mean, there are two things going on. One is the estoppel that Malone Friend is seeking to rely on that forms the basis of the novation. And the other thing which he's now seeking to rely on, which was not pleaded, and certainly this is the first time I've heard Malone Friend making these submissions, is that the very same facts that relate to the novation of the agreement also form the basis of the estoppel of the the clauses 16 and 17. Now they cannot, by definition, those same facts form that estoppel. And that's the point that Lord Sumption makes. You need to actually have a representation related to the clause, not something else. Otherwise, it would never be of any effect. And something, and then he, in the second proposition he makes, is that something more would be required than the informal promise itself. That's Lord Sumption making this point very clear. Simply because you agree to take over payment doesn't mean you also agree that you're waiving the clause. So in my submission, that point doesn't go anywhere. Then I briefly, if I may, deal with my learned friend's, I think, last real point on grounds 1, which is the, well, I think I would describe as the only sensible inference point. He says, stand back, what else was going on? What was if you take away the November arrangement, what other construction is there? Now, I sought to deal with this in the course of my opening, so I won't repeat any of that. But what I say is that it's certainly not clear, anything but clear, what was going on, given the multifarious ways in which the case is put and the different finding of the judge. That's the first point. Secondly, what really was going on here, the essence of it in my submission, was that Astra LLP and then Astra UK was taking over the position of trading advisor under the terms of the 2B and Crown contracts, and to the extent that it was involved in the invoicing and payment of fees under the Octave contract, it was involving itself in the capacity that had previously been occupied by Octave LLP. I've already made that point. I won't repeat it. The parties in my submission clearly were not ad idem over whether that would give rise to a novation or not. The court will recall the exchange between Ms. Galligan, Mr. Siskina having had a look at the terms of the drafts agreement, and Mr. Murray, where she raised the question, why can't we just have a novation? That's the question. Because that's not what was being proposed. They then said, well, why can't we just have a simple novation agreement? And this is the point that my lord also made to Malone Friend. It would have been a very simple thing to simply have a novation agreement, but the parties didn't enter into one. So what Malone Friend is then having to deal with is a situation where one party was suggesting one thing and the other party was suggesting another, and there was no agreement between them as to what would happen. So in my submission, that's not the proper basis on which to submit to the court that there was only one inference that could be drawn from these dealings between the parties. So that's the novation argument. Let me then turn to ground 2. Malone Friend, I think, accepted the suggestion of Lady Justice Falk, that maybe that would provide some assistance to the court. I agree. My learned friend only referred to paragraph 18, which is a sort of kind of summary of Lord Newburger's judgment in Arnold and Britain, but I would also refer to paragraph 19, which of course is the Wood clarification of And I personally found that part of the judgment where His Lordship, Lord Clark, said that, you know, we're not dealing here with competing considerations. They work together. They're both tools, text and context. I personally found that of assistance, and whether my lord and ladies will, that's obviously for you. But in short, I don't dispute that that's of assistance in summarising the position. My learned friend then dealt with his submissions by reference to different clauses. He said that in relation to clause 3.1, this, he said, was the governing clause. In my submission, that is the mistake, the same kind of mistake that the judge made. It's not a governing clause. It's to be read along with all the other clauses of the contract. That's the very point that Network Rail makes. You've got to take into, in interpreting any clause, you've got to take into account the whole of the contract. It doesn't simply set out, as it were, the grant, as my learned friend sought to persuade you. What it does is it defines the term eligible investments. That's its principal function. In order to find the scope of fee sharing, one has to look at the other terms of the agreement, in particular 3.2 that links it, specifies it as being 20%. That, if anything, is probably the governing clause, and also links it to the concept of it being in respect of eligible investments. I also relied on clause 13.1 and 1.1 and 3.7. In my submission, what one has to do is look at all of those clauses together and reach a conclusion. My learned friend sought to rely on an interpretation he put forward as to the second sentence of clause 3.1. He said that what that was talking about was that any investment by any other investor after the initial investor would be regarded as an additional investment. That's just plainly wrong. Additional investments is a term in the second sentence that deals with additional investments by the same investor.
I thought that's what he was saying.
Oh, I'm sorry. I may have misunderstood him then, in which case I apologise. Yeah. No, that can only be a reference to the same investor making additional investments in a fund for current strategy, and that's so it doesn't add anything to this at all in my submission. That's not engaged in this case, and it doesn't actually elucidate the submissions that we've been making. Clause 3.7, my learned friend again is mischaracterising the way we put our case. He says that what we are about, and this is what he's been repeatedly submitting, is that if you have a situation where something that was eligible is no longer eligible, then that somehow means that Musst is not entitled to a penny. And he made these points on a number of occasions forensically before the court. But as the court knows, that's not my submission. Although he claims that that is the inference to be drawn from the pleading, I've shown the court the pleading, and in my submission it makes clear that there is a division between earnings that take place before and when something is eligible investment, and earnings that take place after that time. My learned friend goes further, and he says, I've looked at every document in this case, and if you do a word search, you won't find the word accrual. That's wrong. The very word accrual is used not only in my skeleton argument at trial in Schedule 3, but it's also in paragraph 246, which I can show the court if it would be of assistance. And secondly,
because I spent a long time looking, and I simply couldn't see it.
well, I
The
show.
notion of accrued performance fees being due upon the cessation of the current strategy. I would be grateful if Mr. Bourne, because Mr. Bourne's criticising the judge for not taking this point into account. And I think it's important the court sees how it was put to the judge in terms of the actual reference.
I've just given the court the reference.
Well, no,
paragraph
actually,
246 of my skeleton argument for trial used the word accrual. As my learned friend said, that word had never been used. It was also used in the paragraph that I showed the court yesterday in my learned friend's own pleading, because in response to, you may recall, in response to the defence and counterclaim putting forward the pleading the eligible investments issue, my learned friend amended his claim to plead an estoppel, and in his own estoppel he used the word accrual himself. I can give you that reference if it assists you. Let me find it. I did show the court this yesterday. I'm not sure it's going to assist the court greatly, but I did give my learned friend, when I saw this skeleton argument, an additional bundle with my skeleton for trial, which had this very paragraph that I referred to in it, if it's necessary to go to it. Otherwise, I could provide it to the court if the court would find that of assistance. The paragraph I'm referring to now, which is in the re-amended claim, is, I think it was paragraph 112, no, it's 113. In paragraph 13c, there was a specific allegation advanced by Musst that the common intention and assumption was that if something was converted into a non-eligible investment, then at that point the right to performance fees would accrue. It's on page 323 of the bundle. So that word has been used. My friend's not right about that. I accepted before the judge, and sorry, just to make that point good, with one final thing. I told the court yesterday, again, I had provided my learned friend with the document before I made the submission, and I can show the court if it would assist you. I did, in response to the judgment, take this point. I did say to the judge that that wasn't our case, that it didn't deprive Musst of all of its fee, but that it would be entitled to a fee for the period in which the investment followed the current strategy and therefore was an eligible investment. I did make that point. And that has consistently been my case. Where I think perhaps my friend is confused is that he relies very heavily on the word received. He made that point by reference to many clauses in the agreement a few moments ago. And I accept that it would not become due for payment until it was received. That much I accept. But it would be valued by reference to the period in which it was an eligible investment.
So how would it be valued?
It would be valued in accordance with I showed yesterday the court the terms of the 2B and Crown contracts.
I know, but you don't have a value until you realise it with this sort of investment, surely.
I don't, my lord, I don't respectfully accept that. There are, depending on the type of asset, which could be part of the portfolio, it could be just cash, as my own friend said, in which case it's just the value of the cash. Or it could be, as my own friend suggested, some shares, in which case there would be likely to be a quoted price for it. Or it could be a synthetic product, which could be trading in a marketplace. There are various different alternatives here, and the Crown contract, I did give the court a reference to this yesterday, the Crown contract does have provisions for valuation.
Yes, as between Crown and Astra.
That's correct. That's absolutely right, my lady. It's as between Crown and Astra, but that very same valuation will determine the amount of the performance fee, and that in turn will determine the entitlement under the octave contract.
Do you say to us then, I've just been looking to see, I don't think we've got your skeleton for trial, have we?
No, but I can show.
So, but your cases, because it's obviously hotly contested between you, whether it matters to us or not, is I make no comment at the moment, but your case is that you put this fairly and squarely before the judge and he failed to deal with it. You said to the judge, there's a payout on an accruals basis in terms of the performance fee, and that was all before the judge. It was in your skeleton in two places, but he just didn't deal with it.
Yes, although when I should say this in fairness to the judge,
he had quite a lot to
the
deal
paragraph of my skeleton argument, it wasn't like in bold, and I mean there were many issues in this case.
Yeah, well.
And what I will agree with my learned friend on is that neither he nor I took this the funds point, not the accruals point, the funds point when the judge gave his judgment. Nevertheless, the reason why it was dealt with in the way that it was is because the judge determined in his judgment that the correct way to proceed with the case at this stage was to make a finding, to make an order requiring Astra to provide the particulars in accordance with clause 4.1 of the octave contract, but to leave over to the consequential hearing the quantification of it. And so the judge, having made that direction, and that being contained within the first order that is under appeal, it therefore became part and parcel of the statement that was provided and the consequential hearing. That's the genesis of this. If I could understand my learned friend's complaint, if the point had never been raised before the judge and I was making it for the first time on this appeal, but the very existence of the second appeal shows that I did draw this to the judge's attention. When I accept that I didn't in the comments that were made. There are 40 pages of corrections that we gave the judge on his judgment. I accept that the funds point was not one of them.
40 pages of corrections.
40 pages of corrections, yes. And my learned friend also, there were a lot of corrections, or perhaps...
Oh, that was just from one of you?
That was from one of us, yes. I did, however, draw this to his attention at the consequential hearing, and it's right that my learned friend objected, but he didn't object on the same basis that he is now objecting. What he said was this, that it's too late for this to be taken as a complete defence. Again, I can show the court the transcript of this if it exists. I have given it to my learned friend. But that it was open to Astra to take the point on quantum. And he accepted it was pleaded. So he said the essential point is that it had no merit. So the judge, my learned friend's right. The judge then, when he went to deal with it, said that there was a timing point, but he wasn't concerned by that point. That he wanted to deal with the substance of it, and he therefore dealt with the substance of it. And it's that judgment that I'm appealing. So we don't have a situation where I'm on appeal for the first time, trying to raise a point which wasn't argued below and wasn't pleaded. First of all, it was pleaded. Second, it was in the trial skeleton. Thirdly, I did draw its attention, albeit at the consequentials hearing. Fourthly, the judge actually dealt with it. Fifthly, if I had had to make an application to amend, I would have done. The GATT guidelines, therefore, have absolutely no relevance in this case, or the barrel jurisdiction, because I'm not raising for the first time a point. The judge has actually dealt with it, and the decision under appeal is what I'm seeking to persuade the court is incorrect. In my submission, there's nothing in the procedural point that my learned friend is raising on the appeal. He has accepted that he didn't run the abuse of process point. In fact, not only did he not run it, but he accepted it was open to me to run this point on quantum, which is what I was running it for. I, in exchange for that, accepted before the judge that I wasn't relying on it as a complete defence. I was only relying on it on the issue of quantum. So it's to that it goes. I don't seek to resolve from that concession that I made before the judge. So I hope that is not a lot of hot air, but I just want to give an indication of the extent of the dispute. If it would assist the court, I'm willing to provide the supplemental bundle that has all the references that I've just referred to in it. Let me then turn to clause 13.2.
Well,
I'm sorry, it's 5
do
past.
I
No,
told
sorry.
you.
No.
I told you
No, you
yesterday at the end of the day that we would be finished by 4 o'clock, and now it's 5 past 4.
No, you didn't.
You have another 5 minutes if you need it.
I'm grateful, my lord. I'll take it, but I'm sorry I had overlooked the time when I started that submission. I'm very grateful. I'm conscious that you said you had a meeting at 4 o'clock. We'll finish in 5 minutes. 13.2. I just to make this point. I accept that 13.2 is appearing under a title dealing with termination. However, it doesn't detract from its importance. It doesn't only arise on termination. I say what it shows is that the parties have the same entitlement on termination, whether or not the contract's terminated, the same entitlement arises. It's absurd to suggest that a different entitlement arises, so it's a question of construing the words in clause 13.2. And I've already made my submission as to what they mean. Finally, on clause 3.7, my learned friend sought to persuade you that it was of no relevance because it was all about reinvestment. I accepted yesterday that it didn't apply because that applies on reinvestment, which there's been none. But the relevance is this. The reference to restructuring of the ASSCF fund in the clause shows that when the ASFCF fund is restructured, it is no longer a fund as defined within clause 1.1. And that, and it's a specific restructuring to turn it into an open-ended fund, which is not about repayment of money, it's about the change of the terms. And so when one reads 3.7 with the definition of fund in 1.1, one realises that the last sentence is dealing with exactly that situation. Those are my submissions. I'm grateful for the extra time.
Thank you both very much indeed, and thank you to those that supported you in the preparation of the appeal. We'll think about this and let you have our judgments in due course in the usual way. Please let us have suggested editorial corrections, not on the scale that we've previously been discussing, and a draft order reflecting our decision, please. If there are any matters that you're unable to agree, we'll decide those on paper, and the judgment will be handed down according to the electronic protocol. Please have regard to the warning that conventionally appears at the top of that when you receive the draft judgment as to the permissible distribution. But thank you all very much indeed.
All right.